Greetings, this is Jim Lindsay. This is a lesson about intellectual property and specifically intellectual property protections, and the information that I'll be talking to you about comes from pages 520 through 526 in your textbook. Again, those are pages 520 through 526. That's not a whole lot of pages, and the material I'm going to share with you is actually material that was presented to one of my classes this last semester by an attorney named Miss Laura Hagan. And Miss Laura Hagan is one of just a few intellectual property attorneys in the city of Bowling Green, and it was really great. I mean, I wish I wish you guys could have been there to see the presentation that she made. So she's going to be I have her presentation. She gave me permission to use it, so I'm going to share with you a lot of what she talked about. Not all of it, of course, but I'll share with you a lot of what she told us about, and I think it's going to really illuminate the what you're reading about in those pages. So let's get started. All right, this presentation basically it talks about 4 different types of intellectual property protections: patents, trademarks, copyrights, and trade secrets. And what she shared with us basically was examples of each. She shared with us what type, what sort of things you would protect with each of those different protections, the durations of those, the process for obtaining those types of protections. And she also talked about the fair use policy, which is something that, again, if you're ever going to be a teacher, being a teacher, you'll often want to use things from YouTube or that you find on the internet, and there are certain rules that if you are following those rules, you can use those copyrighted materials in that fair use vein. And so again, this is material that was initially presented by Miss Hagan. You can see her firm is listed there, Carrick Backer, and she's here in Bowling Green. If you have any sort of intellectual property needs, she would be a good person to go and talk with. So let's get started. Let's start with patents. And what is a patent? What does it protect? And well, basically, a patent is an intellectual property protection, which basically excludes other people from using things that you invent. And so an invention would be a thing like a lawnmower or a new fountain pen or a new sort of bottle that you'd put beverages in or something like that. It's something that basically your tangible goods would be really good examples of patents. Machines, these articles that you can manufacture, and also as it lists here, you can patent a process. And so let's say you had some sort of process that you came up with to paint a car or put chrome on a bumper of a car or something like that. You can patent that process. And so these are the sorts of things that you can patent. The duration of a patent basically is 20 years from the date that you file it. So if you filed a patent on January 1st, 1980, in 2000, the patent expires. It's good for 20 years from the date that you first file for that patent. After that 20 years, anybody can use that invention, whatever it is that you came up with, whatever process you tried to you were protecting or product you were protecting. And in the application for the patent, you have to basically divulge exactly, to explain exactly what you're claiming is yours. I have an example I'll show to you here of a patent application. Okay, this is a patent for a briefcase, and this is one of 4 different documents that are on the Blackboard website that you can look at. These are things that Ms. Hagan brought for us to see, but you can see it's very detailed. There's a prescribed format for this thing. You have to include drawings of whatever it is that you're claiming you created, and so this is what a patent looks like. So if you had something that you basically were afraid you weren't going to get the patent, then applying for the patent may be kind of risky, because in the patent application process you have to explain in this document exactly what you do. And so that's what a patent is. Those are the kinds of things that they protect. And here's an example of what a patent looks like. Okay, so this is a utility. As far as the types of patents, there are a couple of different types that she told us about. One is a utility patent. You just saw that briefcase document, and that's an example of a utility patent. And as you can see, it protects the function of an invention. There's also something called a design patent, and you can see this looks like this is a smartphone that came from Apple, and what it does, it protects the appearance only of whatever you're filing. And so in this case, the look of an iPhone is protected by that patent that you see listed right there, and it came in on June 29th of 2010. There are also patents that you can get on things like plants, believe it or not. If you're an agriculture person and you come up, you've probably heard of like GMO plants, the genetically modified organisms, and if you come up with a new kind of plant, you can patent that. And so this one, it looks like, is from Mr. and Mrs. Jackson from Jackson's Orchard here in Bowling Green, Kentucky. And so there are different things that you can patent, and the elements of what goes into a patent, basically, you saw that document we looked at a second ago. You have to include a detailed drawing, and you have to explain in writing, what you did and why you think that basically you should be given this exclusive right to this technology for the next 20 years. If somebody if you're granted the patent and somebody starts to infringe upon it within that 20-year period, you can sue them in a court of law, and you can then win financial reward for their infringement upon your patent. So what are the costs of getting a patent? Well, they're not cheap. She shared this with us. Now, you have these PowerPoint slides are on the Blackboard website for you. I'm just going to race through these as far as the costs go. Suffice it to say, it's not cheap to get a patent. Whereas, and the reason I bring that up, in contrast to that, when you're trying to get a copyright, as soon as you create something, you automatically have copyright protection for it. And to file for copyright is under $50. But in contrast to that, with a patent, you're looking at several $1,000s, and depending upon what sort of thing you're trying to get patented, you can see these different types down here, the different fees and the different times when you have to pay additional fees. It's very expensive, and so this is not something that you'd go into lightly. This is something you certainly would, if you were going to patent something, you would definitely want to do it with a lot of thought, because it's going to cost a lot of money. There's no guarantee you're going to get the patent, and if you go through the process and the patent isn't granted, then you've divulged basically how you do what you claim to have invented. Now, she also brought in another document for us from the United States Patent Office that basically, it looks like this. Let me jump back over to Adobe Acrobat, and it looks like this. It's a brochure, and right now it's an 8.5 by 11 turned up on its side. Here's the second page of it, and you have this document on Blackboard. You can you can look at that in detail on your computer. But essentially, what this thing does is, if you look at this, the United States Patent Office, it says, be really wary of those companies. You've probably seen commercials on television for companies that will help you get a patent. And what this what this document is saying is, be really careful because those guys can be really sketchy. And so it doesn't mean you can't use them at all, but just be very careful in using that sort of an organization. If you have something that you think you really want to patent, you're probably better served to go to a patent lawyer and have them do it for you, as opposed to a company that you see a television commercial for on TV. So please take a look at that. That's that gives you some more information, some details about that. And that's on the Blackboard site down here. That's that U.S. Patent and Trademark Office brochure. Okay, let me go back to the presentation here. Okay, the next type of protection that she talked about was something called a trade secret, and that's exactly what it sounds like. It's a secret, and the recipe for Coca-Cola is one example of something protected by a trade secret. The recipe for the Bush's baked beans is protected by a trade secret, and what the value of that is, there are a bunch of really positive things about a trade secret. One, you don't have to pay anybody for to file things with the government, or you don't have to pay lawyers for it. You just basically, as long as you don't tell what's in the recipe, and it lasts forever. A secret lasts forever until somebody tells what's in the recipe, or somebody, in this case, spills the beans. So trade secrets are really great in the fact that they're a lot less expensive than patents, but and they never run out. But if you lose the trade secret, if somebody gets mad at, within the family, and they tell the secret, and then other people start to make it the same thing as you, there's nothing you can do about it. So you don't you'll lose that 20 years of exclusive rights to that thing that you've thought up. So that's the second type of protection that she talked about. Now, with regard to trade secrets, if let's say you're like Bush's Baked Beans, and you come up with this great recipe for baked beans, and I love their stuff, how would you then start to produce those on a scale big enough to basically, provide stuff nationally and still not lose your secret? Well, use something called a confidentiality agreement with your employees. So anybody that's going to work at the place with you that needs to know that recipe, they are bound by this confidentiality agreement, and if they break it, then there would be tremendous financial penalties for them for basically divulging the secret. So you can imagine, and they probably they only tell the secret to people that need to know it, and so something that you very closely protect, and you employ these confidentiality agreements to really protect those trade secrets. Okay, the third type of protection she talked about was something called a trademark. And a trademark is basically a protection which you get on logos, things of design that you come up with, or words. Like the McDonald's arches, that's an example of something that is protected by trademark. The Nike phrase, "Just do it," that's something that's protected by trademark. And this type of protection, basically, it can last indefinitely as long as you're using the mark, as long as you're using that logo or using that phrase. If you let it lapse, if you basically, let's say a company had something that they used like 100 years ago or 50 years ago, then they stopped, and somebody else picked it up like 50 years later, then at that point that company loses the protection that was afforded them initially. But as long as you're using it, you can continue to get that trademark protection indefinitely. She talked to us about basically when you first create a logo, when you first come up with a phrase, you get basically what's called common law rights to protect it. To actually pursue an infringement in court, you would need to then get either state or federal registration, and then that USPTO that you heard about that had produced that document we looked at a second ago, that U.S. Patent and Trademark Office, you would file with them, and you can do it at the federal or at the state level, and there are different fees for doing it at different levels. She recommended, I believe I remember this right, basically doing it at the federal level, and then you have like the national protection with it. But you know, and that's what a trademark protects. Basically, like those logos, those phrases, and the duration of it is, you know, initially 10 years, but again, as long as you're using that mark, you get indefinite protection of it. All right. So, and by the way, here is the details about the difference between state and federal. If you're just going to operate within a single state, then she recommended state registration. If you're going to have interstate commerce, she recommended the federal registration. And you can see, you know, the filing fees are listed there. It's really cheap if you're in just a state. The federal registration, now that's not very much money. You know, business-wise, that's not a ton of money. So that's some more information for you about trademarks. Okay, and then with trademarks, she gave us a bunch of really good examples as far as infringement cases, and then something that is called the Barbra Streisand effect. Basically, when people go to enforce their trademark protection, but they come out looking like a bully. And so I wanted to cover these things with you because they're really, you know, they're humorous to some, you know, and it's just kind of neat to see examples. So she brought up the Make America Great slogan that was part of the Donald Trump campaign with the last presidential election. And in the campaign, basically, when they started to do this, they filed for a trademark for two different uses. But one of the things they didn't trademark was putting Make America Great on clothing. And so there was a married couple, and if you look in the notes for the PowerPoint presentation, you'll see the details on this. Basically, this couple had, because the Trump campaign hadn't done that, they thought they were going to sell things, and so they got the trademark for the clothing part of in using Make America Great. And so the campaign really got rolling, and they decided that they wanted to have that too, and so they went to the couple that basically had that trademark, and they said, hey, you know, we'd like to buy that from you. And what the couple did is they said, you know, we won't sell it to you, but we'll if you give a $100,000 donation to St. Jude Hospital, then we'll let you have it. And so the campaign did that. And so the campaign got the Make America Great trademark for clothing as well, in exchange for that donation to St. Jude's Children's Hospital. So she talked about what would be the grounds for making an infringement case against somebody. And basically the grounds are that whatever you think is infringing upon your trademark has to basically cause confusion. It doesn't, you know, need to be identical, but it needs to be able to, you know, doesn't have to be identical, but it basically has to cause confusion. And she's got some examples here of those, and you'll see those in just a minute. Also, she said when an infringement takes place, your attorney, whoever your trademark attorney is, would basically use one of these sorts of protections, these sorts of means to protect you. They would send a cease and desist letter to the person who's infringing on your trademark. And what that cease and desist letter would typically say is say, hey, I'm an attorney for Jim Lindsay, and you are using a logo that's very much like his, and it's confusing, so you need to stop. That's what cease. You need to cease and desist. You need to stop and not do it anymore. Your textbook talks about WIPO. That's an international body, that basically a UN level intellectual property organization. And you know, if it's an international sort of infringement, you can go through WIPO. Sorry, I got cut off there. You can go through WIPO to get, you know, them to go on your behalf to try and get some infringing body to stop doing it. With an internet sort of thing, with a web-based sort of thing, you can go through an internet service provider and notify them, saying like, hey, so and so you know, who has a web page that you're hosting, they're infringing upon my stuff, and you know, you need to take this stuff down. And the internet service provider can go about getting this stuff off of the internet for you. And then lastly, she talked about this Barbra Streisand effect. And Barbra Streisand, of course, is a She was a movie star, a singer, and she she had a piece of property, and basically there was a guy who took pictures, not with a drone, and this is back before drones, but basically he was a real estate guy, I think, and he ended up with a picture of some of her property from the air, and she got upset about the fact that he had taken pictures of this property. She thought that that put her at a security risk, and so she went really after this guy and trying to get his pictures and all sorts of stuff. And anyway, she came out of it looking like a bully because the guy was he was just a small-time dude that, whether he was the pilot or the photographer, she came out of it looking really bad. So there's this thing called the Streisand effect, where if you go after somebody for something, even if you feel like you're justified, if you come off looking like a bully, then it's bad for your company. And so she gave us some pretty humorous examples of where that has taken place. And so let me show you a few of these. Here is the first. Okay, the first was from the Penn Law School, actually. They were giving an intellectual property class or seminar, and there's stuff that they put together. It looked like Louis Vuitton. That's not Louis Vuitton, but it looked sort of like Louis Vuitton. And so Louis Vuitton really, came down hard on the Penn State or the Penn Law School program, and so they basically, Penn had to stop, but it came off where, especially because they were going after a group of attorneys anyway. The Penn Law School came out of it better than Louis Vuitton did. Louis Vuitton came out looking like a bully because they, this couple of day event or this 1 day event, who's really paying attention to that? Louis Vuitton probably didn't need to pursue that, but that's one example of the Streisand effect of basically, coming off being a jerk. Here's another one, and when you first see that hat, what do you think of? You probably think of like the North Face clothing line. And outdoor gear. There was a high school kid who had that company called the South Butt, and basically it was stuff I think he was making out of his garage. And so yeah, the North Face went after this kid, and they probably helped him sell a lot more stuff than he would have, but he had to stop because he got the cease and desist letters from North Face, and so that's another kind of funny example. Here's the third one. Chick-fil-A, basically they sent cease and desist letters and went after the Eat More Kale people. Kale, of course, being sort of like a lettuce, I suppose. But they have the Eat More Chicken campaign at Chick-fil-A with the cows, the Holstein cows, and they're always telling you to eat more chicken, but Chick-fil-A went after the Eat More Kale people. So those are a couple of different examples. Those being pretty humorous. I just wanted to share those with you. Okay, now as we've already stated, basically, trademarks, as long as you're using those, you get to use those forever. So that's pretty cool. Let's jump to something called trade dress, and let me pull that up for you. So this is something I'd never heard of until she came to talk to us, but it's similar in the vein of trademark, but basically the look of a package. Certain packages have certain looks, and so let me show you a quick picture here. As you look at that, real quickly, you probably see like Reese's peanut butter cups, Kodak film, Hershey's toothpaste. Hershey's chocolate, and so on. But if you read the boxes for each of those, each of those say Crest toothpaste with fluoride or Forstat, and so the look of the packaging can also be protected through that protection called trade dress. And so she brought that to our attention. I thought that was pretty cool. So we've talked about patents, we've talked about trade secrets, we've talked about trademarks. Let's skip on back to copyright, and we'll finish there. Okay, copyright basically is a protection of basically works of music, of pictures you take, of software you create, of books that you write, And copyright is something basically that as soon as you create something, you have that common law copyright protection. Now, in order to sue somebody for infringement upon the copyright, you'd have to have it officially registered, which you'll see, the cost for that is, about $35 to $55 to get that filed. But this is something that, as you see right here, original works of music, software, books, etc. And that's the reason I really want to bring it up in this class, is because I hope that some of you guys, after learning about all this computer stuff, some of you go away and you come up with some like really cool software or some really cool books or some really cool whatever you want to create. And then I want you to know that it's important that you go and get some legal protection for these things that you've created, because hopefully you're going to be able to gain financially from these creations that you've come up with. And so these are the types of things that copyright protects. And the duration of this basically is your lifetime plus 70 years. And the reason for that is basically you can leave your because you're going to be making like royalty monies from songs that you write and stuff like that. You get this protection and it lasts your whole lifetime. And so that way, if you come up with like let's say you're J.K. Rowling, well, she wrote those books, and so like for her entire life of like Harry Potter stuff, she gets to enjoy that benefit. And after she's gone, she gets to leave that in her will to whoever she wants to, and then they can continue to gain financial benefit from that creation. Now, at the point when after 70 years after her death, then that will go into just the open community, and anybody can use it, and you don't have to pay royalties or worry about copyright at that point. So that's why people can use like Mozart music and Tchaikovsky and stuff like that, because those people are dead and they've been dead for a really long time. But the duration of this is basically your lifetime plus 70 years. I do have that in text for you. Let me get that for you up here on the screen here. Yeah, and the way that you file for copyright is through that copyright.gov office, and you can see those filing fees for copyright. So it's not expensive. It's not difficult to do. My wife has copyright on some stuff that she's written. When she went through her PhD program, she with her dissertation, she basically got copyright protection of that, and it's been cited by other people doing similar research to what she does, and she sometimes gets royalty checks for that. So it's kind of cool stuff to know about. It's not real complicated compared to like the patent stuff. So I hope you guys will benefit from knowing this. Okay, and she also gave us some examples of where copyright infringement has taken place. If you look at these PowerPoint slides, this is a link right here, and I encourage you to take a listen to that song. Basically, Marvin Gaye's family sued basically the Blurred Lines guys, Pharrell Williams and Robin Thicke, and basically if you listen to those songs together, I mean, it really is like, wow, yeah, I can see why they did that. And that website right there, I won't make it you listen to it now, but you can hear how they thought that basically Got to Give It Up would be like the basis for this Blurred Line song. And so she talked to us about things like that. So in order for something to be an infringement upon someone else's copyright, it has to meet these standards that you're seeing right here. And so in this case, that was determined to be an infringement, and they had to pay nearly, like it says right there, $2.6 million in damages. So last point I would like to make in this presentation is something called fair use. And so if you're a teacher, I think you may have times when you want to use things like play movies in class, or sections of things to help prove, to make points and emphasize things. Well, if you're using things, copyrighted works for these purposes right here, educational uses, parody, and so on, then you can get fair use protection. And so, in those cases, you're probably going to be okay. There's a checklist. One of the things that you could download from the Blackboard site is this fair use checklist, and there's Miss Hagen's business card, by the way. So if you guys would like to contact her, feel free. But if you're using it with this checklist right here, check, if you're checking things on the left column here, if that's why you're using a copyrighted thing, then you're probably going to be okay. If you're checking it over here on the right side, then you're probably not okay. And so this is a real helpful worksheet that she gave us if you're trying to figure out whether you're going to be okay to use a copyrighted material for something. I skipped over this one. This is a document that you guys can read about when trade secrets are a better option than a patent, and vice versa. And so that's also out there for you. So let me go back to the presentation to close up here. Okay, so those are the highlights of that. What you read about in those pages of the textbook, plus additional information. I didn't do a tenth of the good that Miss Hagen did when she gave this presentation, and she talked about a lot more. But hopefully, I imparted some of the information to you well. Really, I think this stuff's really interesting, and I hope you guys come out of school, and I hope you do create some really cool intellectual property, and I want you to be able to protect yourself. So, thanks for your time and attention. If you have questions, let me know. You have Miss Hagen's contact information as well. And thanks a lot. Have a good day.